You know what? I have a couple of dismissals here. I've got Dugas, 25 CR 72A, caution, Dugas, that has been dismissed. Hunter Chappelle, I'm dismissing that as well today.
Thank you, sir.
In that case. I gave her right. Thing today. It's kind of fun. Just to review. It's being
You know,
He asked for us to be for me to do that, to see what we think the options were.
yeah.
Okay. Okay, Hunter Chappelle, that case.
Makes my job easier.
17-28063, 10 years ago. That is dismissed. And also, I have case Sheena Miller, 24 CR 2.53. Oh, I like this dismissal a lot better than that other one. That's the spacing. There was no spaces to write it.
Yeah.
I don't have those.
Yeah.
Yeah, I don't know how we did two different versions of.
I don't know. We have to put our bar number on the ones when we dismiss the TRPs. We don't on the ones we dismiss regular cases. This is
All right, here's this one. Thank you, man. Do that because it's
Yeah.
trying to bite me. And now we have 23 CO 1765, the state of Texas versus Michael Johnson Jr. earlier here in last week. You were here and it's pleaded true to allegation 1 and 2. Committing the offense of evading arrest or detention on or about April 1st of this year, and also on that day committing the offense of resisting arrest, and this states in violation of your probation order of May 15th, 2024, where you were sentenced 2 years in the state jail, probated for 5 years for unauthorized use of a motor vehicle. Today, what are we here to do?
Your Honor, I think last week we were talked about getting him into ISF, and I think you requested the probation department to prepare new orders or amendment to the orders.
And where are we?
Okay, so I spoke to the mental health officer as well, because that's where we had
Yes, ma'am.
chose to place him. So I have on my amendment here, I have that he be placed on the mental health initiative caseload. That one is more forensic.
Okay.
So that one's a closer monitoring. He'll get a case manager that he'll meet with once or twice a month.
Okay.
And he'll work through like a management book that helps him budgeting, all that kind of stuff, and help him understand his diagnosis. I also want to put him in MRT, which is the mental reconation therapy class, because I think he needs something to help with that.
Those will be amendments to his probation.
I also think that we should place him on ROP, which is our random drug testing for the next 6 months,
Okay.
to help with that. And then I also said he needs to be placed on zero tolerance, because I think that'll also help as well. He's already done ISF. He's successfully completed.
Failure's not an option.
Yeah.
No problems. I hear one problem, they're going to come to me.
Yes, sir.
And then we'll pick up where we left off. And it's this quick. I've already made the findings. I would make these two statements. The motion to revoke probation is granted. You were sentenced to up to 2 years. 2 sentences. That's all that's between you and you going to prison, but it's really what's between you and going to prison is your actions, not mine. It's yours. So we've horsed around long enough with you. Do the right thing. What do you want to do with your life? I mean, to make the world a better place and you a better person, what do you want to do? What would you like to do? What you have skills. I bet everybody has a gift. Our creator gave everyone a gift of something. What is it that you're real good at? And that's what you do. You find what you're good at and you like to do it, and then do it, and then the world's a better place. What is it, sir?
Build construction.
Good.
There's a lot of that work out there.
But we can help them with job searches and stuff in the office as well. That we get a lot of people sending us like, oh, that we need people, so we can also recommend those to him as well.
We'll be a builder of good things. Plus, a builder of a good life. Here, you're gonna have to sign these. I've signed them, and I want to review in 6 months. Okay, how he's doing? Thank you. Anything else? We're in recess. All right, let's get ready for trial. Thank you. Thank you. Case view, Ada, I'm case viewing.
Yeah.
I'm in a case view.
Let me get
Yeah.
this set work, see it.
All right.
Thank you.
So our recess, we'll bring Yuri in. Let's get to trial. Thanks you very much. Stand by. Record shall show that the jury is seated in the courtroom. All parties are present. And good morning to all of you, ladies and gentlemen. At this time, I'm going to swear all of you in as jurors in this case. Please raise your right hand. Do you and each of you solemnly swear or affirm that in the case of the state of Texas versus Charles Darrell Johnson Jr., that you will a true verdict render according to the law and the evidence, so help you God? Lower your hands. Ladies and gentlemen of the jury, by the oath that you have just taken as jurors, you have now become officials of this court and active participants in the public administration of justice, which is a great honor in a democratic republic like we live in. I always point to the flag that stands for the Constitution. We the people is the way this Constitution begins, and you are the people here who are part of the Constitution, where a trial by jury is ordered as part of the law when a person charged with a crime requests a jury. And without a jury, obviously, the Constitution does not work. So we, the people, all of us have parts to play from time to time, whether it's voting for your favorite public officials or serving as jurors. And that is part of the country working and moving forward. And that's why we are number one on this planet of 200 some odd countries. Other countries that are democratic republics want to be just like us and use the pattern of our Constitution when they form their countries. So it is a great honor to be part of this system where your voice is heard and you are part of the system as it works forward. And not only part of it, it's necessary to have juries. So thank you for your time and energy. Now, if at any time you cannot clearly hear the proceedings, let us know, because we want to make sure that you can clearly hear the testimony from these witnesses. And also, there will be exhibits presented and discussed by the attorneys. We want to make sure that in the gallery here that you can see them and that you can hear the testimony. Let me know if you're having trouble doing that. Now, no one may discuss this case with you during your service as jurors until the end when you go back to deliberate together on a verdict. And likewise, don't feel offended if you happen to run into the attorneys in the hallway or in the elevator and they do a little more than nod to you. To maintain the integrity of the jury system, the law prohibits them from speaking with you about this case, and they may say hello, but it's not going to be much more than that, or how's the weather? But they're not being rude. It's just the law restricts them from talking to you about the case. If someone does contact you or tries to contact you about this case while you are jurors, please report that at once to one of our bailiffs. And likewise, don't discuss the evidence in this case with your fellow jurors until the end when you go back to deliberate after the evidence is presented and the court gives you the instructions. And also when people find out you're jurors, they want to know, what can you tell me? What's it about? And be careful about discussing what you hear here until the end with your spouse, significant others, friends, or anyone else. After you are discharged at the end of this trial, you are free to discuss this case and your deliberations with anyone. And you are also free not to if you wish. And be careful about reading newspapers, watching television reports, or listening to radio reports that might discuss this case. If you do, while you are jurors, turn the sound down, turn the page of the newspaper, or turn the radio down, or change the channel. But be careful about getting outside information about this trial while you are jurors that isn't part of the rules of evidence and the presentation of evidence here. Now, some people like to take notes. If you do, those are for your purposes only. You cannot show them to your fellow jurors nor mention in the jury room that they are indicative of some matter. They can be used only to refresh your own personal recollection of what you may have recorded. In other words, uh, don't say in the deliberation if there's something that you might have taken a note about and it has something to do during the deliberations. Be careful about going, I wrote down earlier in this trial that Joe Blow said blank blank. Don't do that. The way to do it is you can refer to it, but don't show what your notes are. That would be presenting evidence into the deliberation room that is inappropriate. But you might state, I believe the testimony was blankety blank blank. Now, that's a way of doing it, but be careful to follow the rules. Now, don't go to any of the locations referred to by the witnesses in this case, nor perform any type of individual investigation on your own. You will receive all the evidence here in the courtroom. And likewise, don't look in books, encyclopedias, dictionaries, or go to the library or review courthouse records in order to obtain information over and above what is presented to you during the trial. Please listen carefully, as I know you will, to the testimony. No testimony will be reread to you or presented to you in a transcript unless you disagree about a specific statement. And one thing we won't do, sometimes I will get a question from the jury during deliberation. Can we get a transcript of the testimony of Joe Blow? No, you won't. You got to listen the first time. I will give you brief portions of transcript of testimony if you disagree about a particular portion, but you're not going to get to reread the whole testimony. Okay, so keep that in mind. Now, your oath states you will render a verdict only on the evidence submitted to you under this court's legal rulings, and the evidence you may consider will be the testimony of the witnesses from that witness bear under oath, and also evidence may be presented in the form of physical objects or documents, which we call exhibits. During the trial, attorneys make objections, and when an objection is made, I am the gatekeeper of the admissibility of evidence. I have to rule on those objections. And I'm asked a lot of times, you preside over 600 jury trials. My goodness, what is it that you've done that helps you make rulings during trials? And number one, I was on the Rules of Evidence Committee that wrote the rules of evidence here. I like to write, and I've written a lot of articles, and I enjoy doing that and being part of this, but also 10 years as a basketball official. It's the same thing. You have to know the rules of evidence and the rules for basketball, and you have to apply them fairly. In spite of the fact there's 1,000 people shouting at you every time you blow the whistle. In spite of that, there's a lot of similarity. So we refer to the rules, and we have the rules of evidence here. This is the go by of how evidence is properly admitted. There's a form of doing it. You just don't go, here's a stapler, judge, we move it into evidence. Every item that's presented into evidence has to be related, relevant to the matter, and also has to meet credibility. And when it is admitted, then the jury gets to determine exclusively how much weight and credibility to give the testimony of the witnesses and how much weight and credibility to give objects that are admitted into evidence. In concerning and in considering the weight and the value of the testimony of witnesses and other evidence, you can consider a person's appearance, their attitude, their behavior, their interest in the outcome of the case, their relationship to the parties, the inclination of the witness to tell the truth. You can draw reasonable inferences from the statements of witnesses, and you have to do that because there is no case where you will get 100% of the evidence. Even if that's possible, even if you had a video of the event, it will be argued, well, here's the camera over here, but if the camera would have been over here, there would have been a different viewpoint, and there's no end to the what could have, should have. Don't be concerned and get frustrated that we don't have all the evidence. You never do. It's up to every jury in history to fill in gaps using logic and what's called drawing reasonable inferences. And we learned this growing up and in school in logic. Remember when they taught us if something A equals something B, and then something B equals something C, thus logically A equals C, even though we may not have them connected, but they connect by logic, drawing reasonable inferences. You can use your life's experience, your education, your wisdom to fill in gaps. There are certain things that you know it when you see it, and this makes sense to you. This doesn't make sense. And you've got to fill in those gaps using that. And each of you will do it in a different way because each of us have our unique experiences in life. But you are allowed to fill in gaps because once again, you won't get 100%. So don't be frustrated if you're back there going, well, there's some of this we didn't get. You've got to figure it out as well using logic and common sense. Now, the trial is going to proceed in the following way. In just a moment, I'm going to ask the state of Texas to present the indictment. The defendant shall plead to the indictment. Then the parties get to make opening statements, and those are brief overviews of what they expect their case will show. And the statements of attorneys do not constitute evidence. Now, they're important. They're necessary. They are not going to be testifying from that witness stand. Sometimes they do, and that's always amusing. But when a lawyer is questioning the witnesses, and that's the way we do it in historical, we've taken that from the Romans to the English to us. Testimony is presented in a question and answer form. We don't put a witness on the stand and say, tell us everything you know about this event. Witnesses sometimes freeze. They may not be good speakers, and they may be intimidated by the environment. So we have learned that a question and answer method is the way this is done. Lawyers will ask a question. It's not the question that's evidence. It's the answer that's evidence. The lawyer is not the one under oath. It's the witness under oath, and the answer to the questions are what constitute evidence. Of course, the questions give you the context so you can understand what the what the answer is pertaining to. But it's the answers under oath and any exhibits that might be introduced into evidence which constitute the evidence in the case. So the prosecution always goes first in trials. They're going to call witnesses first. Why is that? All persons charged with crimes are presumed innocent unless proven guilty. So the burden is on the accusing authority in the United States. They have the burden to prove their case as alleged in this indictment. And so they're the ones that call witnesses first. And then at some point in time, after they question the witnesses, the defense gets a fair opportunity to cross-examine those witnesses. And at some point in time, you will hear the state say, we rest. And when that happens, the defense has a chance to call witnesses for their side. And Mr. West may question witnesses. And if that's done, the state gets to cross-examine when Mr. West is through questioning. Sometimes the defense goes, we rest, we're not going to call any witnesses. And that happens from time to time. And that doesn't mean the sky is falling or they're throwing in the towel. They're going to, if they want to plead guilty, they can plead guilty at any time. But the defense hasn't pleaded guilty. The defendant hasn't pleaded guilty. And the presumption of innocence standard stands. That's important. It stands unless proven otherwise. And that's whether the defendant stops and says, I'll plead guilty now, or you go back and deliberate and unanimously determine that the state has proven its case beyond a reasonable doubt. Unless that happens, the defendant is not guilty. That's the way the presumption works. And I have told you, the lead article in Texas, you pull Texas presumption of innocence, that's me. I wrote that article. It's still used as the basis for the way the law works. And then the other important thing is beyond a reasonable doubt, another article that's been written. And those are the two basic components of criminal cases. And when you're making your determination, remember the test in all criminal cases is the highest proving level beyond a reasonable doubt. Not beyond all possible doubt. It's hardly anything except maybe the love that we have for people that we know beyond all possible doubt. But proving from preponderance of the evidence where it's used in the courts across the way when somebody sues another person, 50 and a percentage point more greater. And then beyond a reasonable doubt is the greatest test. And that is because a person's freedom is at stake and it is part of the Constitution. We, the people, the United States, in order to form a more perfect union, the preamble begins first, establishes justice right out of the box. Our forefathers were speaking to you, jurors, because that's what happens here by your decision and my decisions. Justice is going to be achieved, and we want to make sure it's done in the right way. All right. At this time, I'm going to ask the state of Texas to present the indictment. The defendant shall rise. Thank you.
The name and by the authority of the state of Texas, the grand jurors for the county of Jefferson, state aforesaid, duly organized as such at the January term AD 2025 of the Criminal District Court of Jefferson County in said county and state, upon oath in said court, present that Charles Darrell Johnson Jr., hereafter styled the defendant, on or about the 9th day of November 2024, and anterior to the presentment of this indictment in the county of Jefferson and state of Texas, did then and there intentionally and knowingly enter a habitation without the effective consent of Nisha Renee Parr, the owner, with the intent to commit assault against the peace and dignity of the state, signed by the form of the grand jury.
Charles Darrell Johnson Jr., as defendant in this case, you've heard the reading of the indictment by the state of Texas. How do you plead to this indictment? Guilty or not guilty?
Not guilty.
Not guilty will be entered into the record. You may be seated. And another thing that I always like to point out about indictments, these are historically based. An indictment begins in the name and by the authority of the state of Texas. And it was before the United States became free in the name and by the authority of the king, because its word for word was taken from the way Old English did it. And we the people took over. The kings aren't part of the United States. We did away with that quickly. And then it states, and on or about a date and anterior to the presentment of this indictment. And I'm not telling you anything you probably don't know. Again, that's a word we used: anterior, before, posterior, afterwards. So anterior to the presentment of this indictment or before the indictment was presented, it is alleged that the defendant did this and what is alleged, and that it ends again historical against the peace and dignity of the state, and that used to be in the old days, but before 1776, against the peace and dignity of the king. So we use a lot of formality, and then it's signed always by the foreperson of the grand jury on behalf of the grand jury. So those are some formalities that are used in the indictment. And I kind of like them because they're historical based and it shows the importance of the whole process. There's a formality here. We just don't, he's charged with burglary. Let's get on with it. There's a formality here that makes it seem important, as it should be when we're talking about the Constitution of the United States. All right. At this time, the court will allow the parties to address the jury, and any opening statements you may want to make. State may go first.
Morning, ladies and gentlemen. Well, you all made the cut. We look excited to be here, but again, on behalf of myself, and I know Mr. West as well, we thank you all for taking your time out to be here. This is opening statement. During this, it just kind of gives us a chance to explain to you what we think the evidence and testimony is going to show in this trial. This isn't a time for us to make arguments or no evidence is going to be presented. This is just giving you kind of a roadmap of what we think will be shown throughout the trial. And with that, I believe the testimony and the evidence in the case, it's going to show that on November 9th, 2024, at around 1:02 p.m., Officer Dominic Gradozzi was dispatched to 2505 South 11th Street here in Beaumont, Jefferson County. It's some of you may know where it's at, Hart's Chicken here in Beaumont. And he was dispatched in reference to an assault. He shows up, and there is an individual by the name of Nisha Parr who's there in the parking lot. Miss Parr had went over there and borrowed one of the individuals at the Hart's Chicken. She had borrowed one of their cell phones to call the police. Officer Gradozzi gets over there, and Miss Parr is telling him that she was just assaulted at her house just down the road by Charles Johnson. And she says he assaulted her several times, and essentially it choked her out where she had went in and out of it. And so Officer Gradozzi's there. She's explaining to them that she'd been assaulted by him. And so obviously they have to get better information on what occurred, right? There's body cam with it showing there's scratches on her neck. There's different bruising ultimately that will be shown. So then they essentially did an interview with her. He had Detective Mindy Freeman do an interview with Miss Parr. As she's going through everything, she explains that the evidence is going to show that she had dated Mr. Johnson for a little while, and I believe it was about a year, and then they'd stopped dating, and she was now dating another individual at this time. And on November 9th, this date, she had left her 3 children, which were Easton, Ava, and Sanaya. They were ages 3, 8, and 13. She had left them there at home at 2480 Rainier Street. And that was her residence. That's Miss Parr's residence where she was renting there. So she leaves the children home. They deadbolt the door. She leaves them with the keys to the house. And she shows back up that morning on the 9th early, and the deadbolt's on. And she knocks on the door to have the children open the door. No one answers. So at that point, she's wondering what's going on. Where's her children? Why aren't they answering the door? She attempts to go through a garage door, get access into the home. The garage door is broken. A lot of you probably face that where it breaks, and you got to lift it up yourself. So she's over there trying to lift this up. And at some point during that, as she's trying to get access into the home, the defendant, Charles Johnson, shows up. She hears his truck pull up, and he gets out and follows her as she's trying to get into the home quickly.
and follows right behind her as she's trying to escape from him essentially, and gets in the house with her and starts assaulting her. At the point they're wrestling around, arguing, and he's assaulting her. You'll hear testimony from her that for several hours he choked her out as she would pass out and wake back up, had drug her
Hold
from.
on for just a second. Mr. West, tell your client not to nod his head or shake his head. It can only be used in an attempt to try to influence this jury improperly. Don't do that, sir.
Yes, sir.
Thank you. Follow the rules. Thank you. Proceed. Sorry to interrupt.
And so you'll hear testimony that as Miss Parr was there, she was being choked out, drugged from one of the bedrooms to the kitchen, and back and forth. And this happened, I believe, for approximately 2 hours. At one point, she asked if she can go. And just to be clear, while this is happening, the kids are nowhere in the home. Right? So her kids aren't there. She's wondering where her kids are. At one point in this, she wakes up. She asks him if she can go to the kitchen to get some water. She asked Mr. Johnson. He says okay, and as she does, she just runs out through the garage, runs out through the kitchen, goes through the garage, and runs across to Hart's Chicken, which is right down the road, and immediately calls the Beaumont police. They respond. Obviously, Officer Gradozzi. And as they're going back to her residence, obviously she tells them what's going on, what just happened. Where are the children, right? So she's wanting to find out where her children are. She goes back to the residence. At this point, they arrive back at the residence. The children are coming from around just down the road where they're coming around the house. They are interviewed, and what is said is that they were essentially, Mr. Johnson showed up early that morning while Miss Parr was not there. He told the children that their mother had sent him to pick them up. He takes them over to his apartment where he's staying and leaves the children there as he comes back and assaults Miss Parr as she showed up at the home. The children were then taken, as Miss Parr fled to Hart's Chicken. They were taken back during that time to the house by Mr. Johnson and dropped off just down the road and went back to the home. It'll be noted at that time, there will be testimony that while Miss Parr was in the house being assaulted and choked, that her cell phone had fallen and out of her hand, that she didn't have it with her. Obviously, ran across the street, had to borrow someone else's cell phone. Well, when the children were arriving back, her daughter had that cell phone in her hand. So that will be something to note there. The daughter had that cell phone in her hand along with the keys that her mother had left her. But the cell phone then ends up in her hand, which corroborates what will be said by both Miss Parr and the children, that he had taken them after he had taken them before and brought them back afterwards, after he had assaulted Miss Parr. Again, her phone was in the house with him as she ran across the street. Then magically it shows back up with the children coming down the road as the police are showing up as well. Miss Parr said that her clothes had been ripped off during this incident and the struggle. She didn't know if she'd been sexually assaulted or not. She just knows she had passed out several times. And without knowing that, there was a SANE exam requested, and for all of you who don't know, that stands for a sexual assault nurse examiner, which any individual that's potentially been raped or assaulted, sexually assaulted like that, they're sent there to the hospital to get examined by a specialist to specifically see if there was any kind of trauma or any evidence there of the actual sexual assault. She never, you won't hear her ever allege that. That was never alleged. It was just unknown whether anything had occurred like that. She went there, had the sexual assault nurse examiner examine her, went through it, and there was you'll find there was no evidence of a sexual assault. I think you'll see plenty of photos presented with bruising around her neck, lots of scratches. And you'll hear from Miss Knighton, the sexual assault nurse examiner, as to the multiple injuries, bruises that she had found on Miss Parr when she examined her. I think at the end of this, the evidence is gonna, speak for itself, all the photographs, all the injuries to her. And I think, that's what we intend to present, and hopefully at the end of it, it'll be clear to you. Thank you.
Mr. West, do you want to make an opening statement at this time? You may.
Thank you.
Yes, sir.
Good morning, ladies and gentlemen. Focus. That's what this case is going to be about. Focus on what's being charged, okay? The indictment states that Mr. Johnson did there intentionally and knowingly enter a habitation without the effective consent of Nisha Renee Parr, the owner, with intent to commit assault, okay? Why do I say focus? Because there's a lot of things you just heard from Mr. Boyd that happened out there. There was thoughts maybe of sexual assault. They're not making allegations about that, but they checked her for that. There's the kids being gone. Maybe there's kidnapping. There's an assault. There's a lot of things that are really bad things. And you're going to hear a lot of bad things that's going to upset you, make you mad, and they're not good. Okay. But focus on what you're here to decide. Those other things are for another day, another time, whatever. You're here to decide, did he enter that house without the effective consent of her with the intent to commit assault? Not that he did commit assault. Did he have that intent? So focus on what is being asked of you, what you have to make the determination, not all this other stuff. Like I said, this other stuff's going to make you upset, make you mad. It's going to be bad. I'm going to lay it out there on the table right now. Okay. It's not good. But you're tasked with deciding, did he commit this burglary? The actual elements that you were told. So listen to that, listen to the evidence, and see how that fits into what is being charged and what you're here to do today and tomorrow, I guess. Thank you.
Call your first witness, Dave.
They would call Mindy Freeman.